Hello, my name is Dr. Tamas Fezer. I'm an assistant professor at the University of Debrecen in Hungary. I'm teaching civil and commercial law, both in a European and a Hungarian perspective, mainly torts, contracts, competition law, and corporate law. I spent 5 months as a Fulbright scholar here at Indiana University, and IU Kelley School of Business asked me to give some lectures on various European law topics, private law topics. Today's lecture is about competition law in the European communities. It's a difficult and probably really hard topic of the European Union law, but we will try to focus on some most important and basic topics of European competition rules. First, we will take a look at the cartels and anti-competitive practices. Then we will analyze monopolies, mergers and acquisitions, and some special European issues such as state aids and public services. The paramount aim of the European communities was to establish a single European market, a common market where goods, services, capitals, persons and businesses are free to move. To achieve this, a compatible, transparent and fairly regulated competition law was necessary. The Treaty of Rome had 2 main articles about competition in the European communities. Originally, these articles focused on 2 main topics: cartels or anti-competitive practices and monopolies. The first regulation on competition law in Europe was adopted in 1962. That was before the European Court of Justice delivered a broad conception of supremacy of EC law. In order to avoid different interpretation and application of EC competition law, the European Commission became the center body of enforcement. In those days, the community had only 6 members, so establishing a competition directorate general in the Commission's administration seemed to be the perfect body and the perfect solution to control competition law. Soon the European Court of Justice joined the Commission and became an important institution in expanding the competition competence of the European communities. In the famous Constant versus Grundig decision, ECJ upheld the Commission's decision that found an agreement anti-competitive even if it didn't make an impact on the market. ECJ found that a potentially negative effect of an agreement between undertakings from a competition law angle could ruin the original aims of a free market in Europe. The extended interpretation of the treaty articles on competition law started with this decision. The work of the Commission and ECJ created a firm basis of EC competition law. But by the mid-80s, the Commission had to face the broadened territory of EC. With the accession of new member states, the Commission was unable to control competition issues anymore, by himself. Furthermore, member states wanted to protect their most successful national companies from the new legal challenges in the EC. A certain collision appeared between the community and national competition law, and soon it was really hard to separate competencies, especially because member states had a certain resistance against the overgrown competition jurisdiction of the Commission. In the 90s, a reform process started, and in 2003, the European Union remodeled competition law and placed national competition authorities and national courts at the center of enforcement. The Commission still retained an important role in the enforcement mechanism as the head of coordination. The European Competition Network was established with the participation of national authorities and the Commission. The mission of the network is to maintain the coherence and integrity of the European competition law system. Since 2004, all national competition authorities and courts are empowered to fully apply the competition provisions of the EC Treaty. Beside the original competition policies of the EU, by now the European competition law focuses on 5 important topics. Treaty provisions on anti-competitive practices and cartels control agreements between undertakings in order to maintain a healthy and free competition in the European common market. Anti-competitive practices of monopolies still remained an important chapter of competition policies, and mainly because of the newly joined member states, this issue is often completed with provisions on public services and state monopolies. Mergers and acquisitions cannot be found explicitly in the Treaty of Rome, but have a close connection with monopolies. As monopoly situation is not illegal but unwanted, a clearing and authorization process was established before putting the transaction into effect. State aid plays an important role among competition policies, and due to the nature of this anti-competitive practice, the supervising of state aids still remained on a European level, monitored by the Commission and the Council. However, any member state has a right to sue another member state provided illegal state aid to place certain undertakings into a privileged situation. That's illegal. And we also have to mention that in many member states the national competition rules nominate certain anti-competitive practices such as infringement against reputation of another undertaking, violation of business secrets, group boycotts, misuse of copyrights and patents, or unfair applications and proceedings. Another important area of competition law in the EU is in close connection with consumer protection, as deception of consumers has not only competition law but criminal consequences in many member states. This slide shows some most important quick facts and differences between the US and European competition law. It cannot be denied that competition law in the US had a major impact on the European provisions and practice. As competition law policies in Europe were created with the establishment of the European communities, the more than 60-year-old US experiences meant a basis for the European legislation and later the interpretation. An important difference is that in Europe, criminal sanctions never belonged originally to competition law. Neither on an EU level nor in the member states, criminal sanctions are not general consequences of violations and abuses against competition rules. And probably the most important difference is the role of state in competition matters. In the US, antitrust law is a matter of private actors. In Europe, certain state authorities, European institutions deal with competition law in an administrative procedure. National competition authorities in the member states of the EU are part of the public administration system of a country, and the proceeding is fairly bureaucratic. Court procedures are not common in entry-level competition proceedings. Courts just review the decisions of competition authorities in an appeal process. Extraterritorial reach of competition law in the European communities is quite similar to the US conception. Actions of foreign undertakings outside the European Union that have an anti-competitive effect in the European Union and violate EC competition rules belong to the extended jurisdiction of competition authorities in Europe. As the European Court of Justice interpreted, the extraterritorial reach, the sole requirement to start a competition law proceeding in the EU, is proving a negative effect of the transaction or conduct on the common European market. Article 81 in the Treaty of Rome generally prohibits cartels and anti-competitive practices. All agreements between undertakings, decisions by associations of undertakings, and concerted practices which may affect trade between member states and which have as their object or effect the prevention, restriction, or distortion of competition within the common market are prohibited. The definition has three important parts and each contains three elements. The first package is about the definition of agreements. EC competition law extends the definition of agreement to not only formal agreements, but hidden agreements, such as decisions by associations of undertakings. Associations are usually alliances of an economic sector or voluntary societies established to hide the original intention of undertakings to harmonize their market policies. And finally, if a certain agreement cannot be proven, but acts and conducts of undertakings show a coordinated attitude on the market, EC law presumes cartel. Concerted practices means more than one coordinated act and conduct of undertakings. Only one act is not enough, the practice has to be continuous. The next definition package of cartel is about the effects of anti-competitive agreements. Beside the obviously anti-competitive real negative effect, a potential negative effect or just a sole intention of undertakings to result a negative effect on the market is enough to conclude a cartel. And the last element of the definition is the result of the agreement. The worst negative effect can lead to a complete prevention of competition on the relevant market, but restriction or distortion is damaging the market too. All prohibited agreements are automatically void, even if there is no decision on it. The European Commission launched a public consultation on a legislative package designed to allow for settlements of cartel cases, where the parties not only acknowledge their involvement in the cartel and their liability for it, but also agree to a faster and simplified procedure. Settlements would aim to simplify the administrative proceedings and could reduce litigation in cartel cases, thereby freeing resources to pursue more cases. The draft proposal would allow the Commission to impose a lower fine on parties who agreed to the settlement procedure. The Treaty of Rome contains some typical cartel situations that are considered to be the most dangerous for the market. Fixing purchasing or selling prices are highly hazardous and the most obvious cases in cartel practice. The other form of agreement contents with high risk factor is the allocation of markets and consumers. These cartels are the so-called hardcore cartels. The importance of hardcore cartels is the fact that these agreements shall never be exonerated under any circumstances. Even if the agreement can fit to one of the exemption categories of EC law, these shall never be exceptions under the general prohibition. If we look through the European system of cartel exonerations, three types exist. A general rule for agreements of minor importance. The second one is a certain group of agreements in special business sectors can be exonerated through EC regulations. And finally, the third one is individual exoneration that can be claimed from the competition authorities. The rule of agreements with minor importance shows that EC law doesn't focus on irrelevant cartels that have no dangerous effect on the relevant market. But we don't have to forget about it that the relevant market is never the whole territory of the European Union. Relevant market has to be identified in every case, taking into consideration the nature of the product, services, the territory of sales and the behavior and opportunities of customers, whether they can purchase the goods in question on the market with easy access. An agreement has minor importance if the aggregate market share of undertakings concerned in the cartel doesn't exceed 10% of any relevant market, on any relevant market. As I said earlier, hardcore cartels shall never be exonerated, even if they fall under the rule of minor importance. The other exclusion under the exoneration rule is if there are several agreements with minor importance, but the parallel effect of these separated agreements result or may result or object to result prevention of competition, restriction or distortion. To summarize the rule, undertakings cannot double-cross the prohibition with cutting up their agreement into small pieces. EC regulations can exonerate certain groups of agreements in special business sectors. This is the so-called group exoneration. These regulations usually contain white, black and gray lists. The aim of group exoneration is that in special sectors, general anti-competitive practice gives the essence of the sector. A good example is franchising. Exclusive rights under a franchise agreement seems to be anti-competitive, but due to the special nature of copyrights, trademarks, and other intellectual property rights, exclusion is the essential element of franchise. Whitelist contains provision of these agreements that are always allowed to use and don't belong to the prohibited category. Blacklist is about the prohibited provisions. Graylist provisions need further inspection, and in certain cases these provisions can be exonerated. And the third version of exoneration is when undertakings ask for an individual permit from competition authorities and prove that even if the agreement seems to be a prohibited cartel, other factors justify its existence. To get an individual exoneration, the claimants have to prove 4 circumstances, preconditions. Prohibition rule may be declared inapplicable if the agreement, decision, or concerted practice contributes to improving the production or distribution of goods or to promoting technical or economic progress, while allowing consumers a fair share of the resulting benefit, and does not impose on undertakings concerned restriction which are not indispensable to the attainment of these objectives, and affords such undertakings the possibility of eliminating competition in respect of substantial part of the product in question. Briefly, the 4 conditions are: first, some kind of economic advantage. The second one is benefit for consumers. The third one is proportionality. And the fourth is avoiding the elimination of the competition. If these conditions are true for an agreement, the authority can give exoneration. But this permission is not forever. Every year competition authorities check and monitor these conditions again. Another way of individual exoneration is when authorities acknowledge the positive effect of the agreement and exonerate it, but only with certain restrictions. Curbing abuses by firms that dominate markets and suppress competitors or harm consumers is the main subject of EC competition law. Article 82 of the Roman Treaty prohibits the abuse of a dominant position. Dominant position itself is not an unlawful situation, but definitely unwanted. But when monopolies make efforts to maintain their exclusive position with anti-competitive instruments, usually with creating impossible circumstances for newcomers on the relevant market, is absolutely against the community's antitrust law. Some conducts the treaty lists as abuse are imposing unfair purchase or selling prices or trading conditions, either directly or indirectly, limiting production, markets, or technological development in ways that harms consumers, discrimination that places trading parties at competitive disadvantage, and imposing anti-competitive contract conditions. Other kinds of conduct by a dominant firm that disadvantage other parties in the market could also be abuses. Practices such as loyalty rebates that would not be objectionable when done by a firm without market power could be considered abuses when done by an undertaking in a dominant position. To find infringement, it is not necessary to show that an abusive practice produced an actual anti-competitive effect. It is enough that the conduct tends to restrict competition or is capable of having or likely to have that effect. Although there is no provision for exemption in the treaty, case law developed exoneration when otherwise abusive conduct is not prohibited if it is objectively justified. Objectively means that the conduct was an economically reasonable or necessary act of the dominant undertaking that should have been done in the lack of monopoly situation. A merger from a competition law perspective is the concentration of economic power in the hands of fewer than before. In the European Union, the regulation on the control of concentrations between undertakings gives exact definition on concentration. The regulation knows two types of concentrations. A concentration shall be deemed to arise where a change of control on a lasting basis results from the merger of two or more previously independent undertakings or parts of undertakings. The second type is the acquisition, when one or more persons already controlling at least one undertaking, or by one or more undertakings have direct or indirect control of the whole or parts of one or more undertakings. The first case, merger, is typical and usually immediately perceptible form of concentration as the number of the undertakings decreases. But in case of acquisition, further inspection is needed to prove the direct or indirect control of another undertaking. Acquisition has the same negative effect in the market as mergers. Although the number of rival competitors doesn't decrease, but due to the control situation, an undertaking loses his economic independence in case of an acquisition. Concentration usually means that one firm buys out the shares of another. The reasons for oversight of economic concentrations by the EC are the same as the reasons to restrict firms who abuse a position of dominance, only that regulation of mergers and acquisitions attempts to deal with the problem before it arises. It's kind of a prior prevention of creating dominant positions in the single market. In the case of Gencor Ltd versus Commission, the EU Court of First Instance stated that merger control is to avoid the establishment of market structures which may create or strengthen a dominant position and do not need to control directly possible abuses of dominant positions. Types of control can be various. The European Commission makes a distinction between sole and common control. Typical form of sole control is when a person holds the majority of the votes. The number of shares are not relevant, only the right to vote. Qualified minority means that although the owner doesn't hold the majority of the votes, but his shares ensure him a special privilege, such as share with priority voting rights. Factual control has many forms. A common situation is when the shareholder doesn't have privileges and majority votes, but still he has the biggest share package and the rest of the shares are in the hand of many other shareholders in small denominations. Common control means that at least two shareholders have to reach an agreement to hold the majority of the votes together. Common control also includes the case when minority has veto rights. A concentration cannot be put into effect before it is notified to the Commission and he has cleared it. The jurisdiction of the EU is valid only for concentrations that have a community dimension. Community dimension means that the concentration has a perceptible effect on the single market. The regulations introduced an objective definition for community dimension. A concentration has a community dimension if the combined aggregate worldwide turnover of all the undertakings concerned is more than 5 billion euros, and the aggregate community-wide turnover of each of at least two of the undertakings concerned is more than 250 million euros, unless one of the undertakings concerned achieves more than 2/3 of its aggregate community-wide turnover within the same member state. If a concentration doesn't fit in the definition, it doesn't mean that he is free to merge. It can easily happen that the national competition law of the member state, focusing only on the national market, requires a prior authorization. This is the division of duties between the EU and the member states. EU has a jurisdiction to concentration with a community dimension, but member states can state rules to control mergers and acquisitions in their territories with national dimension. It's an interesting segment of the EU merger and acquisition law that the Commission has jurisdiction on clearing and authorizing concentrations outside the European Union. A broad interpretation of the extraterritorial effect can be found in the famous Gancor case. The Commission denied the concentration of undertakings registered in South Africa. The concerned South African undertakings appealed to the Court of First Instance as they are not EU-registered companies. The Court found the Commission's decision lawful as the regulation shall be applied to all concentration with a community dimension. As community dimension doesn't require undertakings with EU residents, the appeal was denied. Although the problem of coordinative joint ventures is treated under Article 81, Cartels, we have to deal with the question here in the concentration chapter. Parent companies remain independent, but one common activity will be transferred to the joint venture. If the creation of the joint venture constituting a concentration and has its object or effect the coordination of the competitive behavior of undertakings that remain independent, such coordination shall be appraised with the view whether or not the operation is compatible with the common market. In the appraisal, the Commission has to take into account whether two or more parent companies retain activities in the same market as the joint venture. The other factor to consider is whether the coordination affords the undertakings the possibility of eliminating competition. In KLM and Alitalia case, airlines did not establish a joint venture formally, but created an alliance that made strategic decisions on marketing and cargo transportation. The board of the alliance consisted of members equally nominated by KLM and Alitalia, and unanimous decision needed. The Commission found that this alliance has all the significances of a joint venture. Practicing economic activities, parent companies together have a direct and significant control in the alliance is permanent, not temporary, and parent companies gave up those business activities, became the main profile of the alliance. Merger control is more a formal approval than a simple notification. The Commission published the so-called best practice guideline to give an orientation about the process. The general rules of the procedure can be found in the merger regulation and the Commission's implementing regulation. The best practice guidelines do not set out the process, but give an insight for future clients how the internal bureaucracy of the procedure works. The process has an informal preliminary part and a formal main part. The whole process begins with informal contacts with the Competition Directorate General staff at the European Commission. This includes submission of a briefing memorandum and draft notification documents before any formal filing is made. The formal process begins with submission of a detailed notification describing the transaction, its motivations, market affected, market shares, and conditions of supply, entry, and exit. The Commission is free to use all of its powers to get further information from the parties and others, such as member state authorities. In the first phase, the Commission has 25 working days to decide whether the transaction is open to a second phase inspection. In the second phase, on merits, the Commission has to deliver a decision in 90 working days. Under exceptional circumstances, deadlines in the first phase can be extended to 35 working days, in the second phase to 105 working days. Detailed rules on deadlines make the proceedings similar to a real administrative process, even if the Commission has a certain right to discretion. Because of the special historical development in Europe, public utilities were traditionally state monopolies. The Treaty of Rome maintains the right for member states to deliver public services, establish public undertakings with exclusive rights. Postal services, mass transportation, and communicational services are the classic sectors of public undertakings. Especially in the post-Soviet countries in Eastern Europe, it is still general that public services are provided dominantly by public undertakings. The transformation of the market is not a fast and easy process. That's why EU does not prohibit this situation, but makes every effort not to conserve the monopoly situation of these undertakings. That is why all public undertakings have to observe the general market rules, and all competition rules are applicable for them. Some activities of the state are considered to be prohibited and clear violation of competitive rules. One of these violations is when the member state gives exclusive rights to a public undertaking, but this undertaking is incapable to fulfill his obligations, deliver the services. This results that demand for this type of services remains unsatisfied on the market. In the Höfner case, the German law ensured exclusive rights for a public authority to convey unemployed persons. This was an exclusive right for the authority, as such contracts of private undertakings were void and prohibited. But the German government did not provide infrastructure for this public authority to handle the cases of highly qualified unemployed persons. The ECG ruled that establishing a public authority with exclusive rights in a certain business sector and without the real infrastructure to fulfill his goals is an abuse with the monopoly situation. Another classic example for violation is when the state establishes a public undertaking with exclusive rights, but to practice these exclusive rights, the public undertaking has to commit a violation of law. In the famous Geneva harbor case, a public undertaking in Geneva had exclusive rights for doing dock work. A German ship arrived in the harbor, and because of the local law, he had to pay for the service of the Italian undertaking, although his workers could do the dock work. The ECG ruled that this situation was a violation of law, as the contract price was way over the market price, and every ship had to enter into a contract with the Italian public undertaking. This is a major violation of the general contract principle, freedom of contract, and absolutely eliminates the competition on the relevant market. And finally, a typical violation is when an undertaking with exclusive rights expands his exclusive rights to another separate market. In the GB Inno case, a telecommunication company got exclusive rights from the state to certify every new telephone device before installation. As this company also dealt with manufacturing telephone devices, it was an anti-competitive practice that he got exclusive right to certify the rival competitors' devices. EU competition law allows exemption under the observation of competition rules for public service undertakings. If a public undertaking is providing services with general interest, a certain violation of competition rules are tolerable. Service with general economic interest means those activities that satisfy essential needs of consumers, such as public utilities and undertakings operating uneconomic but vital services. In a case, ECG found that an airline can also be an undertaking with general economic interest, as public authorities compelled the airline company to provide services on a route that was uneconomic just to satisfy the transportation needs of local inhabitants. And there are enterprises with special functions whose services cannot be provided with following competition rules. In the Corbeau case, the court considered that the monopoly would only be compatible with the treaty if the restrictions on competition were necessary to meet a legitimate public service purpose. In this case, the purpose was expressed in terms of the economic equilibrium of the service of general economic interest performed by the holder of the exclusive right. State aids are unlawful interventions in the free market rules. Whenever a state provides aid to certain undertakings, these undertakings get advantage on the market, and this is an unwanted distortion. Any aid granted by the member state or through state resources in any form whatsoever which distort or threatens to distort competition by favoring certain undertakings or the production of certain goods shall be incompatible with the common market. Direct state aids can easily be traced as they are provided directly from the state budget. A much more difficult situation is to identify indirect aids. In the Preus and Electra case, German law forced power supply companies to buy a certain percentage of their electricity needs from renewable energy sources. German law also stated a minimal price that was higher than the cost of producing such renewable energy and much higher than the price of non-renewable energy. ECG had to decide whether the German law is against the EU competition law, as the state obliged power supply companies to buy the energy from certain companies on a higher price. With this act, the state places these companies in a favorable situation. ECG ruled that state aid can only be an aid that is granted from a state resource. Only the distinction the Treaty of Rome makes between direct and indirect aids doesn't mean that every preference the state provides is a state aid. In Air France's case, the French airline Air France had financial problem. A corporation gave financial support to Air France to restore its liquidity. This corporation was established by a state act, supervised by state authorities, and the board of directors were nominated and assigned by the French government. French law allowed the corporation to undertake and collect money from private investments, not only from the state budget. The particular financial support was granted by the part of the company's budget which he collected with his private investment activity. But ECG ruled that even if the financial aid was not granted from the state-supported budget part, a state company's budget is used for purposes originally stated in the act that established the company. The consequence is that a public company's budget belongs to the public sector, and in this case the aid was an indirect state aid prohibited by EC law. The only exception is if a public company is able to make decisions without the control of the state or any authorities of the state. In this Air France case, this public company's leadership was under the control of the government, as the government nominated and assigned all members of the board. The European Court of Justice gave a broad definition of prohibited state aids. In the Germany versus Commission case, the German government gave tax relief for companies that invest in certain areas of Germany. Germany's defense was that this tax allowance was not automatic and available for only pre-described undertakings. Any undertaking can decide whether he wants to invest in the certain areas or not. Tax allowance depends on a business decision. ECG ruled that the definition of state aid also extends to those preferences that depend on the voluntary decision of the beneficiary. Not only cash support, but any tax allowance, tax relief, export allowance, state warranty, investment support, they all are considered a state aid. Every temporary or permanent state act that has a financially positive impact on a company is state aid. We have to find a dividing line between the situation when the state provides an aid to a company and the situation when the state is a private investor. If the state orders services, buys goods and products to run the public sector and fulfill his constitutional duties, he is a private investor, and choosing a company as a supplier doesn't mean that the state provided a privilege for that company. But to successfully prove the private investor rule, the state has to ensure publicity and equality of chances in the selection procedure. This slide presents compatible state aids. Two categories exist, like white and black listing in group exoneration of Carter agreements. The social character of the aid and restoring damages caused by a natural disaster are always allowed. However, aids to promote economic development in underdeveloped areas, promote projects of common European interest, cultural heritage conservation need further inspection to verify its positive aim. The European Commission is continuously monitoring the system of aids existing in the member states. If the Commission finds that aid granted by the member state is not compatible with the common market, he sends a notice to the state. The state has to abolish or alter such aid within a period of time to be determined by the Commission. If the state doesn't fulfill his obligation, the Commission or any other interested member state can refer the matter to the Court of Justice directly. On application by a member state, the Council may decide that aid which the state is granting or intends to grant shall be considered to be compatible with the common market if such decision is justified by exceptional circumstances. The Council has discretionary right to adjudge the aid, and in exceptional circumstances he can justify the aid. The Treaty of Rome authorizes the Council to adopt regulations and determine categories of aid exempted from this procedure. The secondary legislation of the European Union focuses on three types of privileged aids. Horizontal aids are independent from the business activity of a company and independent from territory. Such aids help the development of small and medium enterprises, educational and employment supports, supports for research and development, environmental protection supports. Another category of exempted aids is the regional aid. Regional aids can be justified if support regions of the EU with unusually low life standards, serious unemployment rates. Finally, secondary legislation has exemptions for sector aids. These aids support special business sectors that have critical conditions, and supports aim to restore the vitality of these sectors. Illegal practices that infringe competition law may cause individual harm to consumers, not only violate public interest. Consequently, actions against violators of the competition law may take two forms. Competition authorities may commence an investigation where it is necessary to safeguard the public interest in order to terminate and, if necessary, sanction the violation. On the other hand, the persons whose rights were infringed can file civil law claims and thus directly enforce the provisions laid down in the Competition Acts of the member states. The court may grant damages or may even form contractual relationships. It may establish contracts between the parties, compel them to perform contracts, or after establishing that the contract is illegal for it restricts competition. It may apply the consequences of invalidity. Other typically legal practices result damages to a rival undertaking, such as violation of business secrets, group boycotts, misuse of patents and copyrights, and unfair proceedings. Since 2004, national competition authorities joined the European Commission to enforce EC competition law. The Commission still has privileges. If any national authority starts a proceeding under EC competition law against an undertaking, he has to inform all other competition authorities in the member states and the Commission. Whenever the Commission himself starts a proceeding in the same case, before or after the national authority put the proceeding in action, the national proceeding has to be dismissed. The Commission can continue any proceeding in member states. The network of national community authorities and the Commission provide not only an effective exchange of information, but a forum to coordinate best practices and interpretation and application of EC competition rules. National competition authorities also have jurisdiction to clear mergers without community dimensions under the national law and to defend public interest against illegal practices. National competition laws often give power to their authorities to protect the interest of consumers and ensure consumer welfare when undertakings want to achieve illegitimate advantages in the market with the deception of consumers. Thank you very much for your attention.